Hi, my name is David Shapiro. I'm a San Diego-based criminal defense attorney, and today I want to discuss generally what happens when you're charged with a felony. First step in the process, usually when you're charged with a felony is, well, you're arrested. And by the time you contacted my office, in all likelihood, not in all situations, but in most situations, you've already been arrested and you already have a court date. That court date, if it's your first court date, will be your arraignment. What your arraignment is an opportunity to see what, if anything, you're charged with. And if you are, in fact, charged with a crime, you will enter a plea of either not guilty or guilty to that offense or those offenses. In all likelihood, you will be entering a not guilty plea to the charge no matter what the weight of the evidence is against you. The second purpose of the arraignment, your first court appearance, is to determine your bail status. If you've posted bail, there's a good probability you'll be allowed to walk out of that courtroom on the bail previously posted, although that's no guarantee. If you're in custody, your attorney will have an opportunity to argue for a lower bail, hopefully a bail that either you or your family can make. On a felony case at your arraignment, there will be at least 2 new court dates set for the future. One will be your readiness conference. The second will be a preliminary examination, also known as a preliminary hearing. The readiness conference will be an opportunity for your attorney, the district attorney, and the judge to discuss your case. By that time, your attorney will have had an opportunity to receive most, if not all, of the discovery, the evidence against you, whether it's witness statements, police reports, video, audio evidence, whatever there may be. And your attorney will have an opportunity to negotiate the case with the prosecutor in the presence of the judge to see if he or she can work out a favorable outcome for you. If a favorable outcome is not able to be attained at the first readiness conference, there may be additional readiness conferences in the future, or there will just proceed to the second date, which is set at your arraignment, which is known as your preliminary hearing, also referred to as your preliminary examination. That's an opportunity where the district attorney needs to put on enough evidence to show that it's more likely than not that you committed these crimes. Doesn't mean you're going to be convicted at trial. It's a significantly lower burden of proof, but it's an evidentiary hearing. What I mean by that is witnesses are called to testify. The district attorney asks them questions. Your attorney has an opportunity to cross-examine them. And then at the end of that case, the judge hears the evidence and hears the arguments from the attorneys to determine whether or not that low burden for purposes of preliminary hearing is met. If it's not met, great, you're discharged, the case is done. If it has been met, then we go to the next step. There's another arraignment, there's another readiness conference, and a trial date is set in the future if the case cannot be favorably worked out, or if you just want to exert your constitutional right to a jury trial. I hope that gives you at least some answers and a general time frame of what to expect when charged with a felony in San Diego.